If you own your home and you're over 60, there's a protection you can set up right now, often for under $200, that decides whether your family inherits your house in a few weeks, or gets tangled in court for a year, losing thousands in fees along the way. And here's the hard part nobody likes to say out loud. This is one of those things you can only set up while you're still healthy and clear-minded. Wait too long, and the window closes. That's what "before it's too late" really means. I'm not talking about a thief this time. I'm talking about probate, the court process that can quietly eat away at the home you worked your whole life to pay off. Most people assume having it will protect them. It doesn't. Not the way you'd think. So in this video, I'll show you the one deed that lets your home skip probate entirely. When a trust is the smarter move, and the mistakes that drag families back into court even when they thought they'd planned ahead. No fear, just the facts and a clear to-do list. Before we start, if you want to protect what you've built for the people you love, subscribe and turn on the bell. This is the practical stuff nobody explains until it's too late. All right, let's start with the real threat. Let's clear up the biggest misunderstanding in estate planning. When you die, your property normally has to go through probate, a court process that validates your will, pays your debts, and legally transfers what you own to your heirs. And here's the surprise that catches so many families. Having a will does not avoid probate. A will just tells the court how to divide things. The court process still happens. Why does that matter? Because probate can be slow, often dragging on for many months. It can be expensive, with court costs and attorney fees paid straight out of your estate, money that was supposed to go to your kids. And it's public, so anyone can see what you left and to whom. For a family that's grieving, it turns the home into a legal headache at the worst possible time. So the real goal isn't just writing a will, it's keeping your home out of probate in the first place. And for that, there's one tool most homeowners have never heard of. Let me show you. The star of this video is called a transfer on death deed, a beneficiary deed in some states. Think of it like the payable on death designation you can put on a bank account. Except this one is for your house. You record a simple deed that names who inherits your home. And here's the beautiful part. It does absolutely nothing while you're alive. You keep 100% control. You can live there, sell it, refinance it, or change your mind and name someone else anytime, without asking anyone. The person you name has zero rights to it until the day you pass. Then, when you die, the home transfers directly to that person, no probate, no court, no judge. Your beneficiary simply files a death certificate and a short affidavit with the county. And the house is theirs, usually within weeks instead of months. And it's cheap, often somewhere between $15 and a few $100s to set up, compared to the thousands probate can cost. Now the catch, and this is why you check your own state. These deeds are recognized in roughly 30 states plus Washington. Not everywhere. States like Florida and Texas use a close cousin called a Lady Bird deed that does the same job. A handful of states don't allow either. And there the answer is usually a living trust. Each state also has its own rules. California requires witnesses, for example. So your action step is simple. Search your state's name plus transfer on death deed or beneficiary deed, or ask an estate attorney whether your state offers one. If it does, this may be the single highest value document you set up this year. But it isn't right for everyone, so let's talk about when a trust is the better move. A transfer on death deed is perfect if your situation is simple, one home, and you just want it to go cleanly to your kids. But some situations call for a bigger tool: irrevocable living trust. Here's when a trust makes more sense. If you own more than one property, or property in more than one state, a trust handles them all in one place and spares your family from opening probate in multiple states. If you have a blended family, say you want your spouse to live in the home for life, and then it passes to children from a first marriage, a trust can spell that out in a way a simple deed can't. And a trust does something a deed doesn't. It plans for incapacity. If you become unable to manage your affairs while you're still living, your named trustee can step in and handle the property without a court appointing someone for you. The trade-off is cost and effort. A trust typically runs from around $1,000 into several thousand, and it has to be set up correctly and funded by actually putting your home into it. For a complex estate, that cost is usually worth every penny. For a single, straightforward home, the transfer on death deed often does the job for a fraction of the price. Now let's cover the threats that can take a bite out of your home even after you've handled probate. There are two more forces that can reach your home, and most people never see them coming. The first is creditors. Many states offer a homestead exemption that protects some or all of your home's equity from creditors, and it often comes bundled with senior property tax relief that lowers your yearly bill. Check whether your state has one and whether you need to file for it. In some places, it's automatic. In others, you have to apply. The second is long-term care. This is the one that surprises families the most. If you ever need Medicaid to pay for a nursing home, your state can later seek to recover those costs from your estate after you pass, and for most seniors, the home is the biggest asset in that estate. This is called Medicaid estate recovery, and a simple transfer on death deed generally does not protect against it. This is exactly where those ladybird deeds in states like Florida and Texas, or proper planning with an elder law attorney, can make a real difference. If long-term care is a concern for you, and past a certain age it's a concern for most of us, this is worth a conversation with a specialist well before you ever need care. Next, the piece that's most literally before it's too late. Everything we've talked about assumes you're healthy enough to sign documents and make decisions. And that's the real deadline hiding inside this whole topic. If you lose mental capacity from a stroke, dementia, or a sudden illness, you can no longer set any of this up. At that point, your family may have to go to court just to get permission to manage your affairs, which is slow, costly, and stressful. So set up two more things while you easily can. First, durable power of attorney, which names someone you trust to handle your finances and property if you can't. Second, make sure your home is titled correctly and your beneficiary designations are current, because an outdated name is one of the most common ways a well-meant plan falls apart. Do these while you're sharp and healthy, and you spare your family an ordeal later. Finally, let's cover the quiet mistakes that drag families back into probate even when they thought they'd planned. Even good plans fail on small details, so watch for these. Mistake 1. Naming a beneficiary and never updating the deed after that person passes away or after a divorce, if your named beneficiary dies before you and you didn't add a backup. The home can land right back in probate. Mistake 2. Only one owner signing a deed when the property is jointly owned. Every current owner usually has to sign for it to be valid. Mistake 3. Using a generic form instead of your state's specific one, since a deed that isn't recorded correctly may not hold up. And mistake 4. Assuming your will covers everything. Remember, a recorded transfer on death deed actually overrides what your will says about that property. The fix for all of it is the same. Get the document right for your state, record it properly, and review it after any big life change, a death, a marriage, a divorce, a move. A short checkup every few years keeps the whole plan working. So here's your no-fear checklist. 1. Understand that a will alone does not avoid probate. 2. Check whether your state offers a transfer on death or beneficiary deed for many homeowners. That's the simplest way to pass the home directly to family. 3. Consider a living trust instead if you have multiple properties, a blended family, or want incapacity protection. 4. Look into your state's homestead exemption and, if long-term care is a concern, ask about Medicaid estate recovery. And 5. Set up a durable power of attorney and keep your titling and beneficiaries current. One honest note: I'm not an attorney, and these rules genuinely vary from state to state. The smartest move is a single sit-down with an estate or elder law attorney, often a few $100s that can save your family thousands and months of stress. Do it while it's easy, not when it's urgent. If this helped you protect what you've built, subscribe so the next practical guide finds you, and share it with a homeowner over 60 who hasn't set this up yet. One conversation could protect their family's future. I'll see you in the next one.